This is Bentley Tolk of Parr Brown Gee Loveless, and I'm a shareholder at the firm. And today I want to talk about a new ERISA case that discusses proper defendants under Section 502A1B of ERISA. Specifically, there is a Seventh Circuit case, the Larson v. United Healthcare case, that I want to talk about. The facts of this case are that there was a class action against 6 health insurance companies. The plaintiffs alleged that those companies were violating Wisconsin state law by requiring co-payments for chiropractic care. The Wisconsin law requires health insurance companies to cover chiropractic care on an equal basis as other forms of medical care for the same condition. Now here the plaintiffs brought a case under ERISA with regard to benefits. And let me go through the holdings of this case. The first holding is that plaintiffs can bring an action under Section 502A1B of ERISA for benefits that are required by state law when such benefits are not specifically listed in the plan documents. When a plan includes an insurance policy, contract terms mandated by state insurance law become plan terms. That's the first holding. Now the second holding that I want to mention is, this is the meat of it, which is that when there's a claim for benefits under Section 502A1B, it can be brought against an insurance company. Although the general rule is that you would usually have to bring such a claim against the plan itself, here there's nothing in the ERISA statute, according to the Seventh Circuit, that would prevent that type of a claim against an insurer. So a cause of action for benefits, according to the Seventh Circuit, has to be brought against the party that has an obligation to pay. In other words, the obligor is the proper defendant under ERISA for a claim for benefits. Additionally, where the plaintiff alleges that he or she is a participant under an insurance-based ERISA plan, and the insurance company decides all eligibility decisions and owes the benefits, the insurer is a proper defendant under Section 502A1B of ERISA. Now the third part of the holding here is that a plaintiff can't bring a claim for breach of fiduciary duty for imposing co-payment requirements for chiropractic services. Imposing policy terms is not a discretionary aspect of claim administration, and therefore it's not a fiduciary act. Let me go through at this point some of the reasoning behind the holding here from the Seventh Circuit. The Seventh Circuit noted that a claim for benefits under Section 502A1B of ERISA is essentially a contract remedy under the terms of the plan. It can be difficult to identify the plan, and because of this difficulty, courts sometimes equate an ERISA plan with an insurance policy. Now, in the Supreme Court case, the Unum Ward case, there was an ERISA plan that included, the court held that when an ERISA plan includes an insurance policy, the requirements imposed by state insurance law become plan terms for purposes of Section 502A1B. Otherwise, ERISA preemption would leave states powerless to alter the terms of the insurance contract or the insurance relationship in ERISA plans, because the insurer could displace any state regulation simply by inserting a contrary term in the plan documents. According to the Seventh Circuit, Section 502A1B doesn't specify who may be sued or who is a proper defendant. Thus, a cause of action or a claim may be brought against the obligor, in other words, the party with the obligation to pay the benefits. When a plan is implemented by insurance and the insurance company decides contractual eligibility and benefits questions and pays the claim as well, the insurance company is the obligor. Now, when the insurers have both the authority to decide all eligibility and benefits questions and the obligation to pay the claim, contract obligations run directly from the insurer to the plaintiffs. So with regard to a Section 502A1B claim for benefits under ERISA, I'm sorry, let me back up. When you have a Section 502A3 claim for fiduciary duty breach, the threshold inquiry is whether the defendant was performing a fiduciary function when taking a particular action at issue. Here, there were no allegations that were attacking the discretionary aspects of claims administration. There wasn't a challenge to individual eligibility determinations or benefits. Instead, the complaint targeted decision-making about policy terms. In summary, the Seventh Circuit took an expansive view about who could be a proper defendant under ERISA, and really focused on who the obligor would be, and that the obligor would be the proper defendant. So courts will need to conduct a case-by-case determination to decide who is obligated to provide the disputed benefits.